Yeah, these are his,
Okay.
oops, okay, this is, reported in session in clause number 331706, case of style of state of Texas versus Stanley Dion McDonald. Mr. McDonald, is that your full name?
Yes, sir.
Mr. McDonald, how are you doing? That's good. Now, Mr. McDonald, I have before me judge's explanation of rights of defendants without an attorney and a waiver of counsel for purposes of entering a guilty plea or proceeding to trial. The first document has a signature on a and initials on a line that is titled, "I want to waive my right to an attorney and represent myself." And the next document, the waiver of counsel, for purposes of entering a guilty plea or proceeding to trial, also has a signature. Now, you recognize these documents? Oh, once you can come get it. That's the two documents that I just mentioned. Now, the first document, the judge's explanation of rights to defendants without an attorney, has your signature on it. It has a your initials. No, just you could just hold on to it. Now, is everything in those documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, okay. So, Mr. McDonald, you are representing yourself. Is that correct?
Yes, sir.
Okay. Now, let's do this here. Now, Mr. McDonald, have you ever studied law?
Sir.
Okay. Have you ever represented yourself in a criminal action?
Yes, sir.
You have? All right. Do you understand the charges against you?
Sir.
You do? And are you aware of the maximum penalty for this charge?
Yes, sir.
Okay. And Judge, now you charged with a driving while intoxicated, is that correct? Which is a Class B misdemeanor.
Yes, sir.
Okay. And what is the range of punishment?
Thank you. The last carriage was 6 months.
Which is 180 days, that's correct. And the max fine?
$10,000.
No, actually $2,000.
$2,000.
Right.
I wouldn't wear the fines, you know, at the time.
Okay. Now, are you familiar with the exact legal elements for each charge? Do you know what you have to prove?
Yeah, you have to prove that.
What the state has to prove?
The state has to prove that the defendant was operating a motor vehicle under the influence. Well, the first element, operating a motor vehicle while under the influence on the public road.
Well, public place, okay. Mr. Boudreaux? Mr. Boudreaux, could y'all be quiet? We're in a hearing.
I'm sorry, sir.
Okay. Do you realize that if you are found guilty of more than, if you're found guilty of this crime, it may result in a sentence that could require you to be in Jefferson County Jail for up to 6 months? Okay, now, sir, Mr. Hunter, would you please put your mic on mute? And you could put your video off as well. Thank you. And are you familiar with the Texas rules of evidence and Texas case law?
That's right there. I got a chance to look at that, Your Honor.
Okay, so you haven't really had a chance to read it, get that? Okay. Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules?
Yes, Your Honor. I'm aware of all rules for introducing evidence in the hearing, but I just haven't really had a chance to see what they are.
Okay. Now, for example, How do you conduct the voir dire examination? You know how to do that?
Yes, sir. You just pick the jurors you think they're gonna win.
Okay.
In your case.
And what are the grounds for excusing a juror for cause? Yeah.
Whether they prejudice against and other things towards that, like prejudice, bias, and stuff like that.
Okay. And what is hearsay?
Hearsay is, well, one person hearing what somebody else said about something else, but you don't see any direct evidence or not have any circumstantial evidence, just what something you heard about something.
Okay. And what are some exceptions to hearsay? You know any exceptions to hearsay?
I guess we don't have any other means to determine it. I don't know the answer.
Okay. And what is proper impeachment of a witness?
Proper impeachment of a witness would be you had a witness removed because of prejudice and bias or something like that.
Okay. When is character evidence allowed? You know?
When you're trying to ascertain the credibility of a witness, I guess, or whoever you're trying to talk to, the character, check out the character, which was the credibility.
Okay. Do you know when and how to make a proper objection?
Yes, sir. Your Honor, I do.
Okay. Do you know how and when to move for a directed verdict?
Yes, sir. When the opportunity presents itself.
Such as?
When the state doesn't have any evidence to carry forward with the case, and move for a directed verdict or acquittal and stuff like that.
Okay. Do you know how to proffer or offer evidence to protect the record for appeal? Okay. Do you know the proper grounds for a mistrial?
No, sir.
Okay. Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court?
No, sir.
Okay. Do you know how to request and object to jury instructions?
Yes, sir. When the instructions are to the point where the jury has no choice but to go one way or the other.
Yeah. Are you familiar with the Texas Rules of Criminal Procedure? Okay. Do you realize that those rules govern the way in which a criminal action is tried in court?
Yes, sir. I'm aware that there are rules to govern all of this stuff, but I'm just not keen to every particular one of them.
Okay. Now, it appears that you know a little bit about some of the law, okay, that have a bearing on your ability to represent yourself. Now, I must advise you that, in my opinion, you would be better defended by a trained lawyer than you can be by yourself. I think it's okay. I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with all of the court procedures. You're not familiar with all of the rules of evidence. I would strongly urge you not to try to represent yourself. Okay.
Yes, sir.
Now, in light of the penalty that you might suffer if you found guilty, in light of all the difficulties of representing yourself, it is still your desire to represent yourself. If it's still your desire to represent yourself and to give up your right to be represented by a lawyer, of course, you have that right.
Yes, sir.
Is it your decision entirely voluntarily on your part?
Yes, sir. May I speak, Your Honor?
Yes.
I object to this whole line of questioning. The question at hand is this motion to dismiss. The law is clear and certain on that fact. For a misdemeanor charge, you have 2 years to prosecute, and the 2 years is up.
Okay. Now,
Now,
let me just respond to this question right quick. Now, Mr. McDonald, pursuant to the case of Ferretta versus California, 422 US 806, the court is obligated to ask questions similar to the ones that I've just asked to, one, determine whether or not you have the ability to represent yourself. And so these line of questioning is coming from case law. I asked you earlier, were you familiar with case law? Okay. Now, these line of questions is not something that I made up. These are line of questions that's in the law. And so the court has to make sure that if an individual would like to represent themselves, that individual should be aware that, one, they're going to be held to the same standards as an attorney. And two, that the court has to inquire whether or not that person has the ability and whether or not that person voluntarily waives their right to have an attorney, and whether or not that person still would like to proceed with what we call pro se. Okay. Now, Mr. Shearer, you had something you would like to say?
I think the court covered it adequately, and the whole point of it is that apparently the defendant does not understand what presented means.
Okay, so I find that the defendant has knowingly and voluntarily waived his or her right to counsel, and I will therefore permit him to represent himself in this case. Okay, now let me see, of the abundance of caution. Okay. On the abundance of caution, what I'm going to do, the court is going to appoint a standby attorney. What a standby attorney is, that's not an attorney that represents you, but that's an attorney you could confer with, ask questions about how to do certain things, any questions that you have. Okay? Okay. So the next person on the list is Attorney Todd LeBlanc. Okay. This is what's this? This is Stanley McDonald. There's 22nd. Okay, now Mr. McDonald, you. Now, Mr. McDonald, I have before me two motions that you filed pro se. The first motion is filed motion for dismissal. This motion was filed July 1st of 2022. And the second motion is the motion for speedy trial, which was also filed on the same day, July 1st. It was file stamped July 1st, 2022. Now, Mr. McDonald, the state, these motions was e-filed, which means that they was filed through the Jefferson County Clerk's Office and the state, as well as each party was required to be given notice through the e-file system. And I thank Mr. Shearer is with the state. He's here today, but Mr. Shearer has informed the court, and he's also informed you that he did not receive notice of these motions. And the court today, earlier, just made a copy of these motions for it. Is that correct, Mr. Shearer?
Yes, Your Honor.
Okay. So, Mr. McDonald, I do know that you would like to have your motions heard, but the state is also entitled to notice and to give them time to prepare.
Your Honor, I object to that, Your Honor, because the prosecutor was Tommy Coleman, and this guy's new. Can't go that the state wanted to change prosecutors around. You know, that I had one already, so why we got this new guy here?
I don't, what I'm saying is, he wasn't, in fact, you say Tommy Coleman is the prosecutor. The fact that Mr. Shearer did not receive a copy of the motion has nothing to do with Tommy Coleman, because the portal that Mr. Shearer is looking in will be the same portal that Mr. Coleman would have access to as well. Is that correct, Mr.
That is
Shearer?
correct.
So in essence, what I'm saying, they never received the motion. And let's see, so 2804. And so this is what we call a pretrial motions. And our pretrial motions are governed by Chapter 28 of the Texas Code of Criminal Procedures. And so the state obviously, let's see, 2801. Because once a motion is filed, then the court has to set it for a hearing. Okay. And so what the court is going to do, we're going to set this case for a hearing. In the meantime, you have been appointed a standby attorney that you can consult with if you need to consult with that attorney. And that attorney will appear with you at the hearing, so that if you need to consult with that attorney, even during the hearing while you're presenting your motion, that attorney will be available for consultation.
Well, I want to duly noted that I object to all of this proceeding. The state has 2 years to prosecute this case. I'll file my motion for a speedy trial, and I want this done and over with. One way or another, I want to get through with this.
Okay, well, it's duly noted, and in fact, that's what you state in your motion. Okay, that's what you state in your motion. And so, but we just have to have, we're gonna set it for a hearing, what we call an evidentiary hearing, where you can, present your motion, present your evidence, and then the state will have an opportunity to respond to the motions that you have filed. Okay, and so at this time, we're gonna have to give him a date, and we're gonna have to get out a court report to make sure that we have a court reporter here. Okay.
Okay, I'll give them a day to try to find a court reporter,
Okay.
Today.
Okay. Okay, so we'll have some, we should have,
Give them a day and I'll
okay,
contact the court.
okay. Stand over there, you get your reset. Once you get your reset.
Any certain day you want to put this on?
I'm thinking Fridays probably will be better.
In the morning, 30 days.
Yeah, usually like, around 10 o'clock, 11, something like on Friday.
I'll say 10.
Right, okay.
Okay.
You get your reset, once you get your reset, you're free to go and you have a blessed day. You gotta, yeah, put your purse there and stand on the X. This is cause number 332152, case of style of state of Texas versus Michael, is that Jolie? Micah Jolie, Jolie Smith. How you doing, Miss Smith? That's good. Okay,
How are you though?
I'm doing fine. Thanks for asking. Ms. Smith, you're here represented by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
That's good. Attorney Boudreaux, what is your announcement in Ms. Smith's case?
Your Honor, this is the first thing on it. I believe that she would be able to, in my opinion, to qualify for pretrial
Okay.
diversion. I'm going to be sending a letter to Mr. Canal next week. I don't have any secretaries. I'm supposed to hire and get a new secretary coming in next week.
Okay,
But I've been without a secretary now, going on about a week and a half, 2 weeks, so.
okay. So this is what we're gonna do. Ms. Smith, your case is gonna get reset, but since he's gonna be trying to get you into what is called pretrial diversion. And the pretrial diversions, they have a sign up every other month, okay? And what we normally do, we get the month that they sign up, that the sign date is anticipating that you may get in. And we'll reset this case after that date. Because if you get into pretrial diversion, the state of Texas will dismiss the case, right? Once you sign up, and then the court date, you would not have to appear because the case had previously been dismissed. So the next date that they have for a pretrial diversion sign up, I think is in September, but what I'm going to do, I'm gonna set it further because he might not have enough time to see if he can get you in September because the list usually piles up pretty fast. It gets full pretty fast. And so we're gonna put you in the month for the next sign up date, which is November,
Yes, sir.
okay?
Can I ask a question?
Ask your attorney first, tell your attorney. Yeah, he'll be able to tell you,
Okay,
he'll be able to tell you, it's a program that's run through the DA's office. If you get in the program, they dismiss the case. If you complete the program, you can get it expunged, which means erased, deleted, or wiped off from your criminal record.
okay, thank you.
So that's the program he's trying to get you, that he's gonna try to get you in. Okay?
I tried to explain that a little bit to her.
Okay.
It's kind of confusing.
Yeah, but that's basically what it is.
Okay.
All right, so what I'm going to do is, your case is gonna be reset. We're gonna reset her case in November, like second week of November. Or second, third week in November. Just hold on a minute, she's gonna give us a date. Mr. Okay, give us a November court date.
November 4th or the 11th.
Probably 11, was, and I know they have it the first Thursday in of the month.
Okay.
So let's do November the 11th.
Oh, wait a
What
minute.
happened?
No, that's a holiday.
Oh, that's
Veterans
Veterans Day. That's
November
right.
18th. No,
Okay.
yeah, November 18th.
Okay.
Keep pulling these numbers out. of there.
Yeah.
Like, holiday.
Yeah,
Holidays.
yeah.
18th.
Okay, this case is gonna be reset to November 18th of 2022. Mr. Boudreaux is gonna sign for your reset. Once you get your reset from your attorney, you'll be free to go, and you have a blessed day. Mr. Boudreaux, you'll be free to go as well.